number 5 under county judge, request by the county judge for approval to write a letter on behalf of the county, the Water County Commissioners Court in opposition of the proposed high-speed rail system in Water County.
Make a motion to approve.
Second.
Been moved and seconded to approve the county judge to write a letter on behalf of the Water County Commissioners Court in opposition of the proposed high-speed rail system in Water County. It's open for discussion.
Timely response to another threat to the welfare of the Waller County citizens. Thank you, Judge.
Any particular items the commissioners would like to see in the letter?
George, I would just like to be able to view exactly what's being proposed, and then once that is done, then we can come up with, before it's an opportunity to come up with some particular questions and concerns.
There are two proposed routes that have been published. The shortest route is depicting crossing northeast Waller County from south to north, north to south. The capability of that bullet train will be non-stop 150-mile-an-hour speeds.
200.
Yeah.
Well, 150 is what I read. 150, 200. I think there will be probably a very lively discussion concerning that project.
And that's one of the problems. We have some meetings in other counties.
Exactly. And there, once again, I feel like that Waller County is target outside, well, for the sake of being nice, we'll call them entrepreneurs who are seeking to enhance their own financial position, but totally disregard the effect that it has on the outlying countryside, specifically Waller County. I see Waller County as being like, very similar to what the Oklahoma Territory was prior to the turn of the 20th century. If some of you know your history, you know that prior to the turn of the 20th century, the Oklahoma Territory was one of the largest land masses in the continental United States that had not yet been settled by the general populace. And we all know what happened with the Oklahoma land rush. If you look at your map and look at the Waller County as where it fits in the big scheme of things, we are essentially the last unscathed large mass of land that is contiguous to Harris County, Montgomery, and Fort Bend County. They want what we got. And they're coming.
But there's other proposals, and the most logical one would be the one going I-45. They gotta have more than one proposal on anything you do. Power lines, anything they do. Most logical one is 45. They have all the, outside of Houston, they have more right-of-way out there than you ever saw in your life. You'd think there were, I don't know, one time they did something right, they bought a lot of right-of-way. So I don't think, in the long term, I don't think Waller County has a fear for this bullet train. It's most logically going 45 to Dallas than it is to us. So don't get fearful before it's there.
Be prepared.
Fear is not the answer. Questions? Research.
Further discussion? Hearing none, we'll vote on the motion. Those in favor of approval, please raise your right hand. Those opposed, same sign. Motion carried. Item number 6 under Commissioner Precinct 3. 2, excuse me. Consider, discuss, and take possible action pursuant to 157.901 Texas Local Government Code regarding the authorization of retention of legal counsel to prevent county officials and employees who are subject to claims, investigations, and/or potential litigation for actions arising from a performance of their public duties in which the public interest requires the defense of such matters.
Make a motion to approve.
Second.
It's been moved and seconded to discuss and take possible action pursuant to 157.901 Texas Local Government Code regarding the authorization of retention of legal counsel to defend county officials or employees who are subject to claims, investigations, and/or potential litigation for actions arising from the performance of their public duties in which the public interest requires and depends on such matters. It's open for discussion.
Judge, I'm curious as to why we're revisiting this issue. If my memory serves me correctly, somewhere back about May of 2013, when Ms. Kim was still employed by the county, I believe she rendered an opinion at that time which prohibited such action on the part of the Commissioner's Court. I wondered what has changed at this time to determine if is there a new opinion? Is there a new opinion, Mr. District Attorney?
No, Commissioner Amsler, honestly, was a little surprised to see this on the agenda today. And honestly, I'm a bit disappointed. Ms. Kim put a lot of work and effort into that opinion. The District Attorney's Office is not perfect. We do not always get everything right. We've had 6 months for this opinion to be questioned. I'm open to being questioned. I could have requested an Attorney General opinion to tell me that I was wrong, that Ms. Kim was wrong. That was never asked of us. So I'm a bit disappointed to see this on the agenda the day after the election. Honestly, I've already had this discussion with the district judge, who we don't use this provision of the law very much, but the district judge has supervision over the Waller County Commissioners Court. And I've already discussed this matter. He's reviewed my legal opinion. He shares my opinion that this is improper. And honestly, if it's voted to be approved today, he will be instructing the auditor not to pay. I will be instructing the auditor to pay. But in good faith, I will be requesting an Attorney General opinion to say that I'm wrong or I'm right. So honestly, that's the bottom line. If you vote to do it today, it's not happening. And number 2, if I'm wrong, I'll be glad for the Attorney General to tell me I'm wrong, and you can have your money then.
Well, our attorneys have told us the county should pay our fees because, number 1, at the time, I think Mr. Gates brought it out today in public hearing, that why we didn't use our district attorney for our defense, because he withdrew from all things because he said that he had a conflict of interest. And he was part of the DA's decision of our legal counsel at that time. He's involved with that legal opinion. Some of it didn't refer to me until later, but he was advising the judge and different people that they could do things, and they went by his legal counsel. And when he pulled out and said, I have a conflict of interest, how do we go to our district attorney and ask for our defense on any matter? And that's what our bonds are for. Some people didn't like our decision making, but it was no reason for our DA to pull out. And then when he did have a conflict of interest, and he can defend his own self, then he gave up that right. And I'm still saying that our fee should be paid. We did it in good faith, protect the county as a whole. And if the district judge and the DA disagrees, then I think they need to be investigated. Except besides us, because we did everything openly and to the point.
Once again,
Can I speak first?
Sure.
That's apples and oranges. This is talking about paying criminal defense attorney for something that was alleged to be a criminal violation. You would never get the district attorney representing you to defend you on a criminal violation.
That is true.
Secondly, anybody can investigate me for anything. I got reelected yesterday.
Unopposed.
Unopposed. Very good,
Second of
Commissioner.
all,
Thirdly, I lost my train of thought. But anyway, I think the public figures it out.
well,
And as to the conflict of interest thing, I've been advised that Judge-elect Duhan will be executing that conflict of interest waiver on January 1st, and I can finally actually say what really happened.
Judge,
Number one more thing. Our DA took charges from somebody, which I don't know who did. It looked like this. Took a charge against an elected official with no evidence, no nothing. I don't think anybody would take charges against somebody by hearsay. There wouldn't be an elected official on this court or elected people in this room if anybody could take a blank piece of paper to the DA and hire a special prosecutor to investigate a blank piece of paper. And that's what my question to the public is. And if you would like that too. And that's the truth. And if he has evidence, I hope when January 1st come up, I'd like to see the evidence because I never heard it through all the investigation that I went through and to slam my name all over this county on a blank piece of paper. I want to see it. And I want the public and the newspapers to print it. Because there was no proof of I'm speaking myself, not this court. I don't want to think they are saying what I'm saying. But I want to see the proof plastered on the paper and then find out who was wrong and who was right. And that's all I have to say.
I would like to close with one more comment. Here it is, since the primary election, months have passed by. The perception of the rank and file Waller County citizen, and I believe I speak for the majority when I say this, still have a discolored attitude concerning the conduct of members of this court. The perception is so keen and so intense that the results of the primary election bore that perception out in a very strong way. Yesterday's election put the icing on the cake. The perception of the ordinary rank and file citizens of Waller County is that they have lost confidence in this body. You can say what you want to, Mr. McClure.
Well, the election was yesterday.
Gentlemen,
Hold on just one moment,
Judge,
please. I'm
Judge.
answering-
Hold on, let's pass this around.
let me say this. We're getting off the subject here.
No, we're not.
This is what I'm concerned about. I'm concerned about the letter of the law as it pertains to the state of Texas. And if we can, or if we can't. That's the most important thing right here, right now. So I would like to suggest that we table this until, as the district attorney said, we get an opinion from the governor and well, no, we're the governor, so. But anyway, we get an opinion from the Attorney General on this particular matter. Because one thing about it, whether it's done now or whether it's done later, it's still going to be according to the letter of the law as it is in the state of Texas. That's my only concern. I can care. Yesterday was gone, today is new. So I would like to suggest and recommend that we table this until we've had that opportunity.
Table it and get an attorney general's opinion?
Yes, sir.
Table.
No, table it and get an attorney general's opinion.
I do have a question. And back to prejudices and everything out of it. If any public official is subject to being investigated and acquiring the expense to protect their own rights for merely making a decision that's within their authority, and anyone can go demand a special prosecutor or prosecution of that. And then after the investigation is found through the opinion of the investigator, they didn't do anything. Where does that ever stop? Well, who can make a vote? If the city council votes to take out the trash and they're subject to someone wanting them prosecuted for that, if another county official makes a decision and someone doesn't like that, and they demand that they be prosecuted for it, doesn't matter if they get prosecuted for it, they still have to gain the expense. And the only reason they made the decision was in the normal course of their duty as a public official. Where does that stop? You can run the bill up on somebody all you want, and they're stuck with that bill. And the only reason they got the bill is because they happen to be the person who divine providence put in the seat to make the decision at the time. There's got to be a mechanism for that.
There is, sir.
Now, we cooperated fully. I don't think the special prosecutor ever made any bones about that. Sat down with the Texas Rangers, handled every question they had, provided every document they asked for. I do think as a citizen of this republic, I'm entitled to some kind of representation on my side. And I think any attorney would say if you go into a situation like that, even if the guy on the other side is your best friend, you deserve somebody on that reflects or attaches themselves to you for your protection and advice. I think any public official at all deserves that. Now, where's the mechanism by which a public official can be reimbursed or have those costs covered? And if there's no mechanism for that, you guys that just got elected better pay attention, because anybody in the world can demand you be prosecuted. It doesn't have to be valid. The expense is still going to be yours. We saw that against the governor. All they got to do is demand you be prosecuted. But in this case, where's the mechanism to protect those officials from that kind of thing? Doesn't mean an official who, shouldn't, if they did something wrong and they get prosecuted, that's one thing. But we passed every test. And for those that believe in justice, we passed every test. We cooperated fully, and there's people laughing and snickering. You weren't there when the investigation happened. You're operating off of rumor and hearsay. We cooperated with those people willingly and cheerfully, I might add. Come look at it. They didn't find anything. Now, does any public official deserve to be under that gun all the time? I'm asking.
You weren't under that gun all the time. You were under that gun because of perceived lack of transparency between this body and the people of Waller County.
Perceived.
Strongly
But it's
perceived.
not true. So there's a problem. And any public official is subject to the same treatment at any time if there's no mechanism or no protection for that public official.
I would suggest that public officials need to be on their toes at all times, and I suspect.
And that's why we cooperated fully, John.
But I do remember the last statement that the special prosecutors concluded their report with, and I believe that statement said business as usual
But
in
that's
Waller
not the
County
meat
should
and
not be
potatoes of the
tolerated.
article, is it?
That was an article.
What counts is the part where they said they didn't find anything. That last part's editorial, not germane to what actually happened and what they found. The part that says we cooperated fully, the part that says we didn't do anything wrong, that's what's relevant to their job. The last part is some add-on addition editorial they add. And anyone can provide that. But that's not the basis of the case.
I think we're getting off topic.
Well, it's not, Judge, because we were found through the special prosecutor to not have done anything wrong. And now, supposedly, we're supposed to have to bear the full brunt of that expense. That makes no sense. Have you ever been accused of something you didn't do and faced prosecution for?
Yes, I have.
Was it just?
No.
Okay. Do we have a system that believes. And when we go through this process and you're found not to have done anything wrong,
There are many
deserve
people
something?
who were involved in this whole issue that have many questions concerning the way that the investigation was conducted. There has been a lot of dissatisfaction amongst the populace. It just didn't ring true, Stanley. It just didn't ring
We
true.
had a special prosecutor come in, look at everything. You're saying they're tainted?
Well, I'm saying that 2 Texas Rangers came to visit me at my office to interview me. And I believe my comment was to the people that I related the incident to was that was the biggest joke. That my perception of the Texas Rangers was greatly diminished on that very day. That was the most silly little interview I believe I've ever been involved in my whole life.
Well, the Rangers, pretty tough outfit. And
I didn't
that's what
perceive
they
them to
get
be that
called
way.
in
Judge, can we get point of order on item 6 as it's stated here on the agenda, please?
All right, no further discussion, vote on the motion. Those in favor of the motion, please raise your right hand. Those opposed, same sign. Motion carries 3-2. And I think item 7 is included in item 6, the way I understand it, is that correct?
Maybe you're gonna have to vote on things like this,
All right, then we'll go to number 7, discuss.
And I would just caution you, there, that, voting for each individual legal fees is probably prohibited pursuant to AG opinions and case law. And moreover, this office is of the opinion that since all of the commissioners have a similar, if not identical, personal interest in receiving these adequate defenses, it would be extremely difficult for any one of the commissioners to make a disinterested determination as to the other member's liability or for the same potential offenses. So any resolution authorizing payment would probably be deemed invalid because there is not a majority of a disinterested court to authorize the payment for each of the members.
Should we do it individually then?
I think that's what,
So what
you
you
can
think?
do it
motion.
individually, but there's not a quorum to authorize the payment because there's 3 members of the court that are under the same, that were under the same investigation. So
Well,
by default, y'all are not disinterested.
That some case be like on to the offense.
So you're basically saying wait and get an AG's opinion, and then let the new court make that decision, counsel, is that what you're saying?
I would advise that an AG opinion is necessary prior to authorizing
the
payments.
way after.
Do I hear a motion to table number 7?
My motion.
I'll second.
Been moved and seconded to table number 7. Those in favor of tabling number 7, please raise your right hand. Those opposed, same sign. Motion carries 4-1. Item 7 is tabled. Item number 8, discuss and take action to approve payment of, oh no, sorry, that would be, to hear motion to table number 8.
Yes, sir, you do.
Second.
Been moved and seconded to table number 8. Those in favor, please raise your right hand. Those opposed, same sign. Motion carries 4-1. Item 8 is tabled. Item 9, do we need number 9?
Withdraw.
It's withdrawn.
Wait, before we go, who's gonna ask for this attorney general?
I did return. He's the one that's authorized to do so.
I represented that I would.
What, are you gonna get on it right away?
I'll get on it right away.
I appreciate that, Mr. Bishop.
I could have got on it right away in May.
We didn't have the bills in May.